Hi everyone. I think Diviay has joined.
Hello, am I audible?
Yes, you're audible, Mr. Chadha.
Okay, just give me a sec. Shall we start or do we need to wait?
Yeah, I will request if our media team could give sharing access to Mr. Chadha.
Sir, it has been given.
Okay, can you bring him in spotlight?
Yes, sir, I am doing.
So
Shall I,
before we start,
share my shall
people
I
will
share my
keep.
screen?
Yeah, you can start sharing. I'll just give a brief introduction about
Okay.
you, so that everyone who have joined us today has the context of this webinar. So Mr. Chadha is a partner at Singhania and Company. His practice area focuses on advising corporates on various legal issues, including compliance management, corporate policies, due diligence, public issues, private equity, and contract management. So besides this, he is also heading the startup vertical of the firm, which focuses on advising the startups on their compliance related issues and also helping the investors in resolving various legal structural issues involved in the investment rounds. So the reason why we have organized this webinar with you, sir, is that we wanted the startups to get a feel of, what kind of preparation they need to do in terms of the mental preparedness which needs to be there, the paperwork which needs to be there, all the compliances which are necessary so that when they are raising funds, even if they have good traction, a novel idea with them, their valuations are not compromised because of the compliances part and the paperwork. So, with this thought, I will hand over the webinar to Mr. Chadha. And sir, you can please begin the session.
Thank you, Ankit. And let me just share my screen with you guys. Just let me know once it is visible and so that we can initiate.
Yes, it's visible.
So good morning, everyone. So I think Ankit has already given a brief introduction. So good morning to everyone, and thank you, Ankit, for arranging this webinar. So just a brief about myself again. So I am Diviay and I am a company secretary and a lawyer by profession. So I'm working in Singhania and Company, and I am here as a partner, primarily looking at the corporate and compliance matter. And as Mr. Ankit has told you that I am also heading the startup vertical here. So this presentation would be more about how a startup should be, fully compliant while raising the issues and what are the steps basically which are involved in a fundraising process, right? So it's a request that I will, let me just complete this presentation first and then we will have an FAQs specifically for few minutes wherein you can raise your issues. Though that being said, I have already received few of the FAQs which have been already given by the participants, and I've already prepared a response of that. So let us start with this presentation, right? So the presentation's topic is about startups, legal compliance, and documentation for smooth fundraising, right? And so let's start with the concept of a startup. That what exactly is a startup? So this is a new concept. Means it was not there prior to 2016, and the NDA government in there basically bring out this idea of a startup thing in India by having a startup policy which was announced in the year 2016. And the main purpose of the startup policy was to nurture the innovation. So we all know that in India, we have so many innovative ideas with so many people. So to nurture those ideas, this policy was primarily made by the government of India. And the another purpose of this policy was to sustain the economical growth and the large scale employment opportunities. So there are dual purpose. One is to nurture the innovation, and secondly to have an economic growth and to bring employment opportunities for the people. With this intent, this policy was introduced by the government of India in 2016, and it is clearly available on the Startup India website also. So in case if you guys want to read about the nitty-gritties of the policy, though I will cover most of the things in today's session, but in case if you want to have a complete policy, if you want to read it, that is available on the Startup India website, right? Now, the very first question is about that. Does it cover both goods and services? Like the startup may both they are covering both goods and services? Yes, it covers both of them. So either you have an innovative service idea or maybe have an innovative product idea, that would be part of the Startup India policy, right? Now, to become a startup, what exactly is required? So I have seen many people, like they are saying that, you know, we have started a startup, we are doing this business. So my first question to them was just by telling yourself or calling yourself as a startup will not become a startup. You have to satisfy few conditions by which you will become a startup. So if you have incorporated a company, maybe if you are working on a new idea and you are saying that I am a startup, no, this is not the way of doing it. You have to comply a few conditions, and the conditions which I have mentioned in this particular slide, if you look at this slide, it basically talks about 2 bullet points. And why there are 2 bullet points? Because all the conditions which are mentioned in the first bullet point needs to be complied with. It says all the following conditions, right? So there is a word which is and not or. It means all the 3 conditions you have to comply to become a startup. So what are the conditions? Number 1, that you have to incorporate or register yourself as a private limited company or a firm or a limited liability or an OPC. So this is the main organization structure that you should have. And I'm telling you here, it talks about private limited company and doesn't talk about public limited company. That means the companies which are incorporated as a public limited company will not fall under the definition of a startup. So first of all, you should have this organization structure, and then only you can think about moving forward. Then it says it has not completed 10 years since incorporation or registration. So your company or your organization structure, whatever you are making, should not be older than 10 years. So within 10 years, it will get a startup registration or maybe the exemption thing of a startup. If your company or if your organization structure is more than 10 years, you will not be considered as a startup. Plus, your turnover should not have been exceeded rupees 100 CR in any of the financial years. So 100 crore से ज़्यादा का turnover आप में से किसी का नहीं होना चाहिए. So you have to comply with all the 3 conditions. Number 1, again I am repeating, you should have a proper organization structure. Number 2, your company or your structure should not be older than 2 months or 10 years. And third, your turnover should not have been gone past 100 crores in any of the previous financial year. Along with these 3 conditions, you also have to satisfy any one of the condition which is mentioned under bullet point 2. So it says satisfy any of the following conditions. So along with these 3, you have to comply with any one of these. What are these 2 conditions? It says it is working towards innovation or development or improvement of existing product, processes or services. That means there should be an innovation or an improvement of an existing product or maybe a new product, or your business model should have a high potential of employment generation. या फिर आपकी कंपनी या जो भी ऑर्गेनाइजेशन स्ट्रक्चर है, it has a potential of generating the employment. So along with these 3 conditions, you have to comply with any of these 2 conditions. Only then you will become a startup. So this is very important for you to understand that if you are going for a fundraising round, you have to comply with these conditions. Before that, no incubator or no other VC or any other investor will invest in your company as a startup, right? Now, so these are the conditions that you have to comply with. So this is the structure of a startup, right? Now, going further straight to the investment part, because this is what is the main pain point, because I know that all of you are very good with your innovative products and all that thing. So let us straight away move to the main pain point, which is about steps before investment, the how to get the investment. What are the things that you should be ready with, or what are the things that you have to consider, or what are the processes which are involved in a fundraising process. This is what I'm talking about in this. So the brief is that there would be a pre-investment scrutiny by an incubator. So any incubator or maybe any VC, any fund, if he wants to invest in your company, they will do a pre-scrutiny, pre-investment scrutiny, which primarily involves checking your innovative product or your innovative idea or the services or the processes that you are developing. So this is where they want to see that whether you have an innovative thing in your business or not, right? So this is being done by the incubators. There is no hard and fast rule. There is no process which is defined. Every incubator has its own way of assessing or doing a pre-investment scrutiny. So nothing has been mentioned under the law, but what we have seen from our practical experiences, it will more move around your investment page, your product page, how you're going to impress the prospective investor, how you will convey your innovative idea to the prospective investors, so that they would be interested in investing in your company. So once they have this pre-investment scrutiny done, then they means that investors will take this to their investment committee. So investment committee, again, it is an in-house committee of the investors, wherein, so let's assume they have pre-scrutinized around 10 companies for the purpose of investment. They will take these 10 companies to their investment committee. Now this investment committee will again reassess all the things. They will reassess the things. They may ask you, for coming up for another round of presentation, or maybe they may ask some certain documents from your end, basis which they will start the startup. They will select the startup wherein they would like to invest, right? So these 2 points are something which are to be done at the investor level. And for this purpose, for these 2 points, what you have to do is you have to prepare yourself with a proper pitch so that you can convince, right? So once you have been selected, now this is where the actual work will start. Then it comes a term sheet. I will explain all these points in detail, so don't worry. This term sheet, due diligence, documentation are the main points of this presentation. So I'm just giving you what are the further steps. The next step would be to have a term sheet. What is term sheet would be covered in the next slide, followed by a due diligence, and followed by the following of the documentation. Now let's move to the next point, and I will show you that what exactly is a term sheet. So this is the first document that you will get from your investor. What is a term sheet? So this is a non-binding understanding. So this is very important for you to understand. This is non-binding. That means even in case if you have got a signed term sheet from an investor, it doesn't mean that you will get an investment out of it. It is non-binding on them, non-binding on you also. So even if you are not happy with the amount of investment or with the amount of stake that they would like to have in your company, even you can get out of it, right? So this is a non-binding understanding which contains the summary of the commercial terms agreed. So whatever you guys have agreed, let's say they have said that, okay, we are going to invest 1 crore in your company, for which we would be getting around 5% stake, 10% stake, 5% or 15% stake, whatever. So that basic understanding would be covered in the term sheet. So whatever discussions or whatever mutual understanding that you guys have with the probable or with the prospective investor, that would be part of a term sheet. Again, I am stressing on this point. This is a non-binding thing, and you can always come out of it in case if you are not happy with the amount of investment or with the amount of stake or with the rights that they are seeking in your company, right? So what term sheet will give you? It will give you a fair idea of direction where the transaction is headed. So you will come to know that what exactly is an ask from the investor side, whether you are happy to go ahead with that, whether you are convinced that, okay, this is fine, this will help my company to grow. So this is how a term sheet will help you to assess that whether this investment, how this investment will sail through, and what are the rights that you are going to give to the investor. So in a nutshell, it is a summary of a commercial terms, which is non-binding. Confidentiality. Now, this is very important for you to understand. Till the time you have signed the term sheet. So it has a specific term, as I mentioned below, between say 30 to 60 days. Between this period, whatever time period of the term sheet have, you cannot disclose the terms of your term sheet to anyone. So the purpose of the term sheet is to stop for luring around, to stop for window shopping. So what we have seen in our practical experience is that, the startup basically signed a term sheet, and on the basis of that term sheet, they will go to the market, or they will go to the another investor and say, "Ki boss, they are investing 1 CR and they are taking 5% stake. If you are happy, you can also invest 1 crore. We will give you 4% stake. If you are happy, you can come in." So these are the things which startups usually do, or the founders usually do. To stop this thing, a confidentiality clause would be there, wherein it will be a clear prohibition on your end that you cannot go for window shopping. You cannot disclose the terms of your term sheet to any third party. You cannot go to the market or to the investor and say that we have a term sheet. Now please come and invest in my company, right? So, and what other things are there in the term sheet is the various rights and terms and all the things of the definitive agreement. So it also talks about, in nutshell, that what are the rights that you are going to give to the investor. What are those rights? I will cover in the subsequent slides. So it will also talk about those rights in a very small, in a very summarized manner. The main descriptive part of that would be in the definitive documents, which I will cover at a later stage, right? So as I've said, it has a specific term. During this term, you cannot go out for any window shopping, and it will also have a clause for exclusivity. Means that during the term of this term sheet, till the time this term sheet is valid, there is an exclusivity clause. That means you cannot go out for shopping, or you cannot tell any other investor to come in that, right? So during that term, that period of say 30 days, 45 days, 60 days, whatever, you will be bound to only work with that investor for the purpose of investment. As I've said, once this term is over, this term sheet is non-binding. After that, you can go around, you can move around. But again, just remember that confidentiality clause sometimes may be inserted in the term sheet in such a manner that you may not be able to disclose the terms of that investment to any other investor, even after the term sheet term has been expired. You have to keep this in mind, right? Now, what are the other things which are there? So it will talk about the investment, how much amount is to be invested. Let's say they are going to invest 5 crores, 10 crores, 1 crore, whatever. So it will talk about the investment amount, type of instrument, like how this amount will be, how this investment will sail through, like what type of instrument you are going to issue. Like it will be a equity, or it will be a preference shares, it will be a debt. What exact instrument you are going to issue would also be part of the term sheet. Then it will also talks about brief terms like CPs and CS. So CP means conditions precedent, it means that you have to comply with few conditions before you are getting the investment. And CS, like there are few conditions that you have to comply with after you will get the investment within a specified time period. It will also talk about the exit mechanism, that how the investor will take an exit, say after 5 years, 7 years, 3 years. That would also be mentioned in the term sheet, and how you are going to use this amount. Like it will be used for the purpose of your goods, your services, getting any machinery, whatever. So the usage of amount would also be mentioned. Plus, it will also mention the rights of the investors. In short, that what are the various rights that they will get in case if they sail through with the investment. There are various rights that we will read, that we will discuss at a later part of this presentation. Those rights would also be mentioned in a term sheet. And a very important part, which is the valuation, means what is the valuation of your company. So you are saying that my company is valued 2 crore. So, and if you are giving 10% to them, that means they are going to invest around 20 lakhs in your company. So what is the valuation of your company? That also would be mentioned in the term sheet. Now, this valuation has to be done through a chartered accountant that you have to remember, or maybe a registered valuer. This valuation is very important because basis this valuation, the investment amount will be decided by the investor, that how much investment they are going to do in your company, and what is the amount of stake that they are going to get in your company. So all in all, term sheet is a short document, which is around say for 4 to 5 pages maximum, which will contain the summary of the entire transaction in a very summarized manner. And as I've said, it will be valid for a particular time frame, say 30 days, 45 days, 60 days, during which You cannot go out for any window shopping, and it will have a confidentiality clause also. So this is the first step in case if you are going for an investment, to sign a term sheet. So this is a commercial understanding that you will have with your investor. And I'm repeating this thing once again. This is non-binding either on you and on them also. So you can get out of it, they can get out of it. So getting a signed term sheet doesn't mean that you have secured an investment for you. Okay. Now, what comes next after the term sheet? So let's say you have signed a term sheet and the term sheet period is say for 60 days. Now, during this 60 days, we have to complete so many things. And this is where the work of lawyers or the professional will come into the picture. So the very first thing that will happen after the signing of a term sheet is the due diligence. What is the due diligence? Due diligence basically means a complete investigative analysis of your company. We will check each and every aspect of your company, how your company is doing, what are the documentation you are maintaining, whether you have proper documentation or not, what are the red flags in your company. So because see, and from an investor standpoint, they would also like to invest in a company wherein the proper processes and proper documentation is maintained. In case if they are not happy with the due diligence, in case there are so many red flags, I am telling you, in spite of the fact that you have a term sheet, you will not get an investment. So this is a very important aspect from you. I am going to discuss this in detail right away to tell you what exactly is required under the due diligence process. So due diligence, as I've said, is divided into 4 parts. One is a financial due diligence, then legal due diligence, operational due diligence, and personal due diligence. So let's start with the legal due diligence first, which means checking the legal status of your company, checking the compliance status of your company. Very important thing for you because you have to maintain lot many documents. So this is where the problem arises for a startup. This is what we have seen, that startups are so involved, or the founders are so engrossed with their own innovative product or an idea, that they don't even think about maintaining these documents or maintaining these legal things with them. And this is where the problem arises. So legal due diligence talks about review of your compliances. It talks about all the applicable laws which are applicable on you. So it doesn't mean that you are a startup, so nothing will be applicable on you. No, it's not the case. Though you guys have got lot many exemptions, but still Companies Act, income tax, GST, all the other acts would be applicable on you. So don't ever think that I am a startup, government has given me a complete relaxation. No, this is not the case. You have been given exemptions on few of the compliances, but rest all of the compliances you need to comply with. It also talks about review of material agreements, like for example, you have some agreement with your main customer, with any main vendor. So we will review those agreements also and see that how these agreements have been drafted, what are the liabilities that you are getting out of these agreements. All these things are very important from an investment perspective. Check the relevant licenses and permits. So whether you have applied for any IPRs, trademark, patents, copyrights, we will check those licenses, we will check those things with you. And I'll tell you here that a very common problem with the startups is that they have applied for the IPRs, but in the name of the founder, not in the name of the company. And this is where the problem will come. Investor would also always like that the IPR should be in the name of the company, in the name of the startup, not in the name of the founder. So a very common problem that we have seen, and you have to make sure that whenever you are applying for the trademark or patent or a copyright, always apply in the name of your startup, that is in the name of the company. Don't apply in the name of the founder, because in case if you have done this, then during the due diligence, this point will be pointed to the investor and they may raise a red flag out of it. So you have to make sure, right? Corporate governance of the company means like how your company is being structured, what is the organization structure, how many directors are there, what is the background of those directors, whether those directors have any have done any sort of default in their previous organizations or not. We will check all those things. Then we will also review the policies that your company will have. For example, POSH policy, which is very important and applicable on almost all the companies, like prevention of sexual harassment of women at a workplace, this is what is posh policy. Then in case if you have a site, then we will, and the privacy policy of your website. So all those things, all those policies we will review and see whether these are in compliance with the laws or not. And the filings that you have done with the relevant authority. So you have to do a lot of filings, like you have to file a lot of returns, forms, documents with the authorities, with the Ministry of Corporate Affairs, with the Income Tax Authority, with the GST Authority, with the labor law authorities, whether you guys have actually filed those documents or not, whether those filings have been made on time or not. Is there anything which you have not filed, so that we have to take the corrective action? Maybe we have to file those documents in the current date with the late filing fees, or maybe we have to go for, say, compounding, that let's say there is something for which the delay is not allowed, then we may have to go to the ministry and ask for the compounding out of it. So all these things will come out when we will do your legal due diligence. A very important aspect, and I'm telling you that after term sheet, between term sheet and the investment, this due diligence is the most important thing and the most common thing due to which the investment didn't sail through. So you have to make sure that you have all these things, you have all the compliances, all the registers, all the licenses and policies ready with you, so that once we will ask for these documents, you should provide us these things, right? And this is a Okay, so this is the template. This is a template that we usually ask. These are the things that we usually ask your charter documents. So we will ask for the memorandum and articles of your company. We will ask for the list of directors, list of shareholders. So I'm just giving you a brief that how this legal due diligence is done. What are the documents that we usually ask for? So this is a template of that. We will ask for the details of the auditors, open contracts, right? Any property that has been owned or leased to the company, all the agreements that you have entered with, list of your employees, any ESOP policies there or not, any ongoing litigations against the company, maybe against the directors, right? Any type of loan that you guys have taken, the startup has taken, right? Any insurance that your company has taken, all the IPRs. This is very important for you, as I've said, that the IPR should be in the name of the company. So list of all those IPRs that are registered, and it will also include the pending registrations. Let's say something has been applied for, you have not received the IPR, even in that case, we will ask for that. Any regulatory registration that you have done with any authority, right? And any existing shareholder agreement. In case if you have already have an existing shareholder who has invested in your company, we will also ask the details of that shareholder also, right? So these are the main things that we will review in a legal due diligence, and the main purpose is to check the compliance status of your company, where the main purpose is to see that whether you guys are properly maintaining the records or not. And in case of anything which is like which is not being maintained, we as a lawyers will basically raise a red flag out of it, and we will see that how these things can be corrected. So the purpose of legal due diligence is not only to raise the red flags, but also to take the corrective actions. So that doesn't mean that by doing a DD, we will also point out the mistakes. We will also advise you that what are the things that you can do so that these mistakes can be rectified as on today date, right? Then we will also do the financial due diligence. Herein, we'll check the financial health of the company. We will check the compliances under the various statutes which are applicable, like the accounting standards. We will check accounting principles. We will check. We will also talk about the debt, how much debt that your company has taken, what are the entries that you guys have passed for it, whether they have been properly accounted with in your financial statement or not. What is the status of your tax compliance, whether you have filed the income tax return, TDS return, GST returns, all those things would be checked here. And check the qualification report of the auditor. So auditor of your company will generally in their report will talk about any sort of mistake that you guys have done. So this is what is known as qualification. So we will review the auditor report of your auditor and see whether they have raised any alarm for it or not. And we will also look at the cash inflow and outflow, that whether these are being properly accounted in your company or not, whether you guys are doing cash transactions, whether guys are properly maintaining the accounts of all the inflows and outflows or not. So that is the prime purpose of doing a financial due diligence. So legal due diligence, wherein talks about the compliances under the Companies Act and other acts, This financial due diligence will basically focus on the accounting principles, accounting standards, income tax provisions, and GST provisions, right? And this is a template of the checklist that we usually ask for doing the financial due diligence. We'll talk about the profit. We will ask the profit and loss account detail, like from where you guys are getting the revenue, what is the employee cost, are you guys are paying any sort of rent, professional fees, or what are the expenses that you have done towards the marketing, technology cost, other expenses. And we will also look at your balance sheet, that what are the assets that you guys have, any receivables and advances, what is the cash balance, bank balance, what are the liabilities, how many borrowings and debts you guys have done, and what are the investments you guys have made, related party transactions, direct tax, indirect tax. So we will check each and every aspect. Again, the purpose is not only to raise the red flags, but also to rectify those mistakes, right? And then comes the commercial due diligence. Commercial due diligence basically talks about due diligence of your business activities. So the prime focus is to review your business activities, like whether you are doing your proper business activities or not, whether the idea that you are saying this is innovative, whether that is actually innovative or not, whether there are other competitors which are there in the market, which actually says that your idea is not innovative. There are already so many competitors for the same type of work that you are doing. So this is where the commercial due diligence will come. And a very important, another due diligence, which is known as personal due diligence. What is personal due diligence? Herein, we will do the due diligence of the founders of the company. We'll do their background check. We will see that how many companies that they have worked with or operated in the past, what is the status of their earlier projects, whether any sort of litigation is going on against those founders or not, whether they guys are into any sort of defaulter list of RBI or not. So that is the main focus of doing the personal due diligence. So all in all, there are 4 types of due diligence. I'm again repeating, just summarizing it. Legal due diligence to check your compliance status under Companies Act and other statutes. Financial due diligence to check the status of your tax and GST compliance and accounting standards. Third is commercial due diligence, which is more about checking your business activities. And fourth is the personal due diligence, which is about checking the background details of the founders of the company, right? So this is the step that we will conduct after the term sheet. Now, if you remember, at the time of term sheet, I have said that the term sheet would be applicable or would be in existence for around 45 to 60 days, or maybe 30 to 60 days. So during those 30 to 60 days, we have to complete this due diligence, and we also have to complete the other documentation. So those 30 and 60 days is basically to review everything. And in case if everything sails through, then we will go towards the next part, which is the agreement, right? So after the term sheet, we have done our due diligence. We will share the due diligence report with the investor, where investor will see that how many defaults your company has done, what are the red flags that we have raised, and whether we have taken any corrective actions or not. Basis our due diligence report, investor will take a call that whether they will go ahead with the investment or not. So term sheet plus due diligence के बाद क्या आता है? Shareholder agreement. But due diligence is the main thing which will move on to the shareholders agreement part. Once you have this agreement in place, then it is sure that you are going to get the investment. So for getting the investment, what you have to do, you have to pass the test of due diligence. For due diligence, what you have to do, you have to maintain the proper records, registers, you have to comply with the law, and you have to complete that, right? So let's assume we have signed a term sheet. After the term sheet, we have done a due diligence. You sailed through with the due diligence. Let's say there are few red flags. We have taken a rectified step. Everything is sorted out. It may happen there are few things which are still not sorted out. What will happen with that? In that scenario, we will, in the shareholder agreement, we will talk about CPs and CS. CP means conditions precedent, means these are the things that you have to comply with before getting the investment. So what happens, let's say there is a non-compliance issue for which another 10 days would be required. So what we will do, we will go ahead with the signing of the agreement. In the agreement, we will say that this condition has to be complied with by the founder within 10 days of signing the agreement. So you will not get the investment in case you will not comply with the CP. So CPs and CS will help you, will basically give you I can say a breather, wherein you can comply with the red flags which have been raised against your company, right? So we will move ahead with the shareholder agreement. Shareholder agreement is basically one agreement is known as share subscription agreement. Another agreement is known as shareholders agreement. Share subscription agreement is basically, in short form, we call it as an SSA. So what is an SSA? SSA lays down the terms of the specific transaction. So now let's say your DD has been done. We are going ahead with the transaction. Now you will have to sign two agreements with the investor. One is known as SSA, which is share subscription agreement. Another one is known as shareholder agreement, in short, which we call it as SHA, right? Sometimes instead of having these two agreements, we can have a single agreement also, which is known as SSSHA, which means shareholders and share subscription agreement. So it may happen your investor will say, we will not sign two agreements, we will sign one agreement. In that scenario, what will happen? We will combine the SSA and SHA and prepare one single document. So it doesn't matter whether these are two documents or one document, it will contains those conditions which I'm going to tell you right away. So what is SSA? It talks about the subscription. Let's say I'm an investor. I'm going to invest 1 crore in your company, for which you are going to issue me an equity of say around 10%. Let's assume hypothetically, right? So the SSA will talk about this transaction, that I am going to invest 10 crore and you are going to give me 10% equity. How this equity will be given? You will transfer me or you will issue the new shares. In how many days it will be done, how you are going to issue the share certificate to me. So this transaction will be covered under the sales subscription agreement. Just mind you, SSA does not contains any rights which you guys have given it to me, right? So it will not create any right. It will only talks about the transaction, that how the money will flow and how you will issue me the securities. This is what is an SSA. This is a comparatively shorter agreement because it only talks about this transaction of getting the money and getting the invest and issuing the securities, nothing else. The main, so this is where the subscription comes. So what it contains, it will contain the type of instrument, what type of instrument you are going to issue to me, right? Whether it will be an equity shares, whether it be a CCPS. CCPS means compulsory convertible preference shares, or CCD, which is compulsory convertible debentures. So we have to see. So this SSA will contain about the type of instrument. It will also talk about the valuation of your company. As I've said earlier, valuation is very important for you because this is where the I will decide that how much I am going to invest in your company. So this SSA will also talks about the valuation of your company, details of investment amount, 1 crore, 2 crore, 3 crore, whether I'm going to pay you in one tranche, maybe in two tranches, how this investment will flow. This will be covered in SSA. Per share price, what is the per share price that you are going to issue to me, whether it will be 100 rupees, 110 rupees per share, 450 rupees per share, whatever is the per price. And securities, like how you are going to issue the securities to me, in what is the time frame in which you will issue a security to me. So these 5 things would be covered in the SSA. And as I've said, this is a shorter agreement which does not talks about any rights given to you or given to me as an investor. Then comes the main agreement, which is known as SHA. Now, this is the main agreement because it outlines the rights and obligations of the parties. Now, this is where the actual negotiation will happen. See, SSA is only about transaction, getting money, giving money, getting the shares. That's it. The actual negotiation happens in SHA because this is where I, as an investor, will try to get as much rights as I can. And you as a founder will try to restrict on those rights. I cannot give you these rights, right? So this is the main thing in which the negotiation will go, right? So it outlines the rights and obligations of the parties. It will also talks about founder's commitment, that how a founder would be committed to the company. So we will make sure in the SHA that you as a founder will not leave the company after getting the investment. See, from an investor standpoint, I am not only investing in your company, I am also investing in the founder, right? Because the founders have come to me for an investor pitch, right? So how the founder's commitment will be there with the company, that would also be part of SHA. And it will also talks about other things like how you will give me an exit, what will happen in case of a dispute, how this agreement can be terminated. So all those clauses would be part of SHA. This SHA is a very comprehensive agreement and a very big agreement as compared to SSA. And as I've said, this is going to be the main negotiation point. So once you have arrived at a term sheet wherein you have commercially agreed on various understanding, so one negotiation goes for term sheet wherein you will agree on the understanding. Second negotiation will go on the SHA, because this is where there would be a tussle of getting the rights and restricting the rights. So this is a main document for you. Now, these are the few clauses which investor will usually ask for. So I have just mentioned few clauses which an investor says that I need these rights. And this is where you have to basically negotiate with the company or with the investor that I'm not going to give you all these rights. Let's negotiate on that. So what are the main rights that a company, that an investor will want to have? One is a preemptive right. What is preemptive right? The preemptive right gives an authority to the investor that in case if you are going for a future round of funding, first you will offer those shares to me, right? I will also have a right to subscribe to future round. So let's assume I have invested 1 crore in your company. You are doing business, you are growing up. Now you want to raise another round of funding. You are saying, I also need another 5 crore. I want to issue more shares. Now, under the preemptive right, you have to give those shares first to me. You have to ask from me whether I am interested in getting those shares or not. And once I'll say no, only then you can move outside. So this is known as preemptive right. You have to come to me first. Then next right which an investor will get is anti-dilution. What an investor will say, boss, I have invested, let's say 1 crore in your company for say 5% stake, right? You go for a further round of funding, I don't mind. मुझे फर्क नहीं पड़ता है. It's good that you are going for a further round of funding, but in the next round of funding, your valuation should not be lower than the valuation at which you have offered that stake to me. So this is where the valuation role will play, because what will happen? Let's say I have invested in your company at that time, maybe your company's valuation was say around 20 crore, right? I have invested in your company. You are going for a next round of funding and now your valuation has been decreased from 20 crore to 15 crore. Now, it will not only decrease company's valuation, it will decrease my stake in your company also. Because see, I have invested 1 crore. That 1 crore is maybe today, maybe 80 lakh rupees. So this is where the anti-dilution role will play, that I will say to you that boss, whenever you are going for a further round of funding, your valuation should be more than the valuation that you have offered to me. And in case if that is not the case, let's say your company is not growing at that place or your valuation has decreased, what will happen? At that time, I will say, okay, boss, give me additional securities to adjust the investment that have been done by me. I will ask for the additional securities. Boss, okay, you are going ahead with a 15 crore valuation. Compensate me for this. Give me additional shares, maybe at a face value of 10 rupees, maybe at a zero value, but you have to give me the additional shares. So this is where the anti-dilution role will come into the picture, wherein an investor will seek and try to get as much as from you in case if your valuation has decreased. Liquidation preference. Now, what investor will seek, that in case if your company is going for liquidation means your company is going for a closure, you will first give money to me. I will need a preference out of it. This is what is known as liquidation preference, that I will seek a preference whenever your company is going for a liquidation. Right of first offer. Now, this right of first offer comes at a time of transfer of shares. See, remember, there is a difference. Preemptive right comes for additional shares. That means new shares are issued, I will have a right. I will also restrict you that in case you as an company, as a founder, if you would like to transfer your own share to any third party, you will not do it without my permission. Right of first offer means that you will give me the first offer right. You will give me the offer. Boss, I as a founder would like to sell my shares. So I as an investor will say, ki, boss, I will have a ROFO. Means first you will offer those shares to me, then I will say no to it, only then you can move on. So ROFO would give the investor a comfort that founder cannot sell its own shares without asking from me. Another one is ROFR, ROFR, which is right of first refusal. I may have any one of these. So ROFO will give me a comfort that whenever you are going outside, you will first come to me. ROFR, on the other hand, said you can go outside, no problem. You can go for window shopping. If you want to go to the market and say, I as a founder would like to sell my share, go boss, don't worry. But that transaction cannot be done without my refusal. So you have to first give me a right to refuse. So I will restrict your window shopping right. You cannot go out. Here I am saying go out, no problem. Take the market rate, try to get an investor who will pay you something. But before executing that transaction, come to me. I will see that whether I can match that thing with the investor or not. After that, I will do it, right? So this is where ROFO and ROFR will come into the picture. Investor will try to get both these rights, any one of these rights, and basically, मान के चलो that in every transaction they will get these rights also. Tag along right. Now this is what ROFR is not exercised. Means you have gone for an window shopping. Let's say you have gone to an investor wherein you as a founder have said, I will sell my 10% stake for 1 CR. Now I have a ROFR. You come to me and said, कि boss, मैं अपने 10% shares बेच रहा हूँ and that investor is going to pay me 1 CR. I am saying, boss, I am not comfortable in paying you 1 CR. Please go ahead with your transaction. Please sell your shares to the investor. But here I will get a tag along right. I will say, okay, boss, go ahead with the transaction, but you have to make sure that your new investor will also buy my shares. This is known as tag along. That means I will be tagged with you. If you are going out, take me along with you. This is known as tag along. So the purpose is to protect an investor's money. And the purpose is to restrict the promoter, restrict the founder that you cannot go out for window shopping. If you want to go out for window shopping, go ahead, boss. Also take along with me. मैं भी आपके साथ जाऊंगा, मैं भी stake बेचूंगा. Because if you are going out, but I have invested in your company on your face. If you are going out, take me along with you. This is known as tag along right. Now, along with that, investor would also like to have some sort of say in your company's board. It will say board representation. It will say, boss, I will appoint a director in your company. So let's say you have incorporated a company with your friend. You have a registered startup. I have invested 1 crore in your company. I am saying, okay, boss, I am ready to invest 1 crore, but you have to give me 1 board seat. 2 directors would be you and your friend. 3rd director will be I. So this is where I want a board representation. This is a normal negotiation. So they may ask for board director seat or they may ask for board observer seat. There is a difference into it. Director means on the board of the company, wherein he will be participated in taking all the decisions. Observer means he will not be on the board of the company, but he will be invited in all the board meetings to see what exactly you guys are discussing. So any of these rights can be taken by the investor. And the purpose is to participate in the day-to-day business of your company, to see that whether you guys are properly working on it. Then another point which is very important is, which an investor will always take, is a reserve matter or an affirmative voting right. Means, see, I have invested 1 crore in your company and I have taken a 10% stake, but 90% stake still belongs to you. And as per law, if you are holding 90% shares, you can take any decision. Forget about whatever I have invested. Right? You can take any decision because this is what is given to you by the law. Now, I as an investor would like to restrict on that. I said, okay, boss, though I am holding 10%, but I also want some sort of a say. I also want a protection out of it. Just by taking a board seat, I don't have a protection because almost every major matter goes to the shareholders, and shareholders are, you are the main shareholders because you are holding 90%. I am just holding 10%. How I will ensure that you guys are not taking any bad decision? This is where reserved matter or affirmating voting right will come into the picture. What I will do, I will put up few matters in front of you and I will say, boss, if you want to discuss or approve any of these matters, in spite of the fact that I am holding 10%, you have to take my consent. This is known as reserved matter and this is allowed under law. This is allowed under law. So what I will do as an investor, I will say, boss, these are the 10-15 matters. Now, please go ahead with these matters. Don't, and if you want to pass any of these matters, please go ahead, but you have to take my approval. This is known as reserve. These matters are reserved for me. In spite of the fact that you are taking 10%, that I am holding just 10% in your company, I can still make a hold on all the major decisions of your company by taking this right? Next is information covenants. I will seek information from you on regular basis, maybe on 15 days basis, monthly basis, quarterly basis, or half yearly basis, whatever. I will say, boss, you will have to provide me an unaudited financials every month, or you have to give me a revenue details every month or an expense sheet every month. So these are the information covenants that I will put, so that I will make sure that in case if you are taking any decision, right, or in case if you are doing any operational activity, it is known to me, right? So all the operations of the company which does not require any approval from the board or shareholders would be managed through the information covenants, wherein I will seek regular information from you so that I would be aware that how you guys are working, whether you guys are properly running your business or not, and this is where I will put a restriction on you, right? So these are the few rights which are to be taken, which would be taken by an investor, and this is where the negotiation will happen. So that's why I've said, because you will try to restrict and say, I will not give this right. Investor will say, I will take this right. So you have to do negotiation. You have to arrive at a consensus wherein both of you will have some sort of a say. But telling you very frankly, and sorry to say this, but investor will have an upper hand in case of a funding round, because you guys need the fund, right? So you have to agree. You have to agree on most of the conditions that will be put up in front of you. So this is an unfortunate condition, but see, if you're getting the money, you have to obey with the directions of your investor also, right? So this is how the SHA will conclude, right? So SSA and SHA, these are the two agreements. So again, just to give you a stepwise, first term sheet will happen where there is a brief understanding. Then due diligence will happen, which basically talks about the compliance status of your company, followed by the agreements, which is SHA and SSA. Once you have all this in signed, that means your investment is secure. Once you have SHA and SSA signed, after that you will get the money from the investor and you can carry on with your business operations. So this is the complete process of having a fundraising day. Now, going further, what are the various avenues of raising the funds? Now, this is very important for you. कहाँ से आप fund ले सकते हैं? So venture capitalists means private equity investors. They basically are very interested in giving the funds to the startup. Angel investors, these are high net worth individuals like HNIs. These are the individuals with high net worth. They are looking for that how their investments can be multiplied. So these individuals are very much interested in investing in your company. IPOs. IPO is another way by which you can offer. But to be very honest, IPOs are very difficult for a startup because you cannot go to a public with an innovative idea only. You need to show your company's revenue and assets and balance sheet and everything. So this is another way of raising, but a very, very difficult way for a startup to raise this. Then mergers and acquisitions, you know, the investor may purchase the stake in your company, or you may buy another. Let's say you have a cash and you are seeing that there is another company which is, may become your competitor. So you may go and buy out that company, or vice versa. You are working on a product, there is a larger company and they may buy out your company. So this is also one way of raising the fund. Then crowdfunding, in case if more than one investor are invested, let's say family hai, friends hai, maybe there is a group of friends who are interested in investing, right? So this is known as crowdfunding. And bootstrapping, it means using your own capital. So very, very difficult and very so own capital or bootstrapping is something which is not very common in case of a startup. But yes, there are few startups. I have worked with couple of startups wherein there is only bootstrapping, that they have used their own fund to set up their their company. Now, let's talk about the compliances part also. So we have seen that due diligence may we are doing the compliances and all. So what are the various compliances that you have to comply with? So these are the four main compliance area that you have to consider. One is the Companies Act, which is the main thing that you have to comply with, because you are a company, you are a private limited company, or maybe LLP, then you have to comply with the LLP Act, or maybe an OPC. OPC is again followed under the Companies Act, right? So Companies Act is something that you have to comply with. And as I've said earlier, uh, relaxations are there, but it doesn't mean that the act is not applicable on you. You still have to do a lot of compliances. You have to still have to do a lot of filings with the ministry. You have to maintain lot many documents. You have to maintain registers, records, file annual returns, file balance sheet. So all these things would be part of the Companies Act. Tax compliances like income tax compliances are there. You have to file income tax return, TDS return, file your advance income tax, or maybe quarterly tax, whatever. So you have to comply with all those things. GST, if GST would be applicable on you, then you have to comply with the GST regulation. And sectoral compliances. Let's say you belong to a particular sector. Let's say you are a fintech startup. That means you have taken the approval from the RBI. Then you have to comply with the RBI regulations also. So sectoral compliances arising wherein a particular sector has been given some few additional compliances to comply with, right? So these are the main compliances. And as I've said, so I've just written these compliances here again. So these are the compliances under Companies Act and the tax and GST. Advanced tax payment you have to comply with, income tax return, tax audit you have to do, payment of tax, which is GST and TDS. GST return you have to file, TDS return you have to file. In case of a Companies Act, you have to conduct board meetings, directors disclosure, appointment of auditors, annual filings you have to do, you have to file return of deposits. So these are the main compliances that you have to comply with. And in the due diligence also, we will look at all these documents, all these filings, all these records that have been maintained by you, whether you are properly maintaining these things or not. And in case if something has not been maintained with, we are going for a corrective action wherein we are going to file it in today's date, maybe with a late penalty fees, maybe with condonation, maybe with compounding that we have to see, right? And here are a few of the incentives for the startups I have just mentioned under the Companies Act. So for the startups, the cash flow is not mandatory. So financial statement may you have to maintain 3 documents. One is balance sheet, profit and loss, and cash flow statement. But for startups, cash flow statement has been do away with. So as I've said, under Companies Act, you will have some exemptions. So one exemption is that you don't have to maintain cash flow statement. Annual return can be signed by a director and no company secretary is required. So under Companies Act, the annual return that we file on an annual basis of a company, that has to be signed by a practicing CS or by the company's own CS, that has to be signed. But in case of a startup, that condition has been do away with, because in most of the startups, company secretary is not required. So only a director signature will do. So this is the exemption, right? So instead of having 2 board meetings in a year, you guys can have instead of having 4 board meetings in a year, a startup can have only 2 board meetings. So this is where the relaxation has been given, that there is no requirement of holding 4 board meetings in a financial year. Instead, you can only hold 2 board meetings and that will suffice. So this is again one of the exemption that you have. Under the deposit rules, you have been given an upper amount limit. So deposit is a section under the Companies Act which basically restricts that a company cannot raise the deposits beyond a particular amount. But for a startup, that there is a relaxation, you can raise deposits at an X number of amount. There is no upper limit, no amount limit is given to you for the first 5 years of your incorporation. That means you can raise the deposits as much as you can without any sort of a limit. Then no labor inspection will be conducted in your company in first 3 to 5 years of the start of your company, right? So no labor inspections will be done. You will do your self-assessment, you will file the return, and whatever you are filing in first 5 years, labor ministry will say, okay, we are fine, we are not going to conduct any inspection in your company. External commercial borrowings are basically borrowings that to be arranged from a foreign country. So if you are arranging a loan from outside India, therein you have lot of relaxations. But if that company is not a startup, there are so many compliances. But in case of a startup, there are lot many relaxations, and you don't have to comply with a very cumbersome process, right? In case if your company is going for a liquidation, right? Let's say you are going for a closure of your company, then instead of 180 days, your company can be closed within 90 days. So relaxation has been given, that time period has been decreased, right? And very important relaxation, you can avail tax holiday for 3 consecutive years in first 10 years. That means in the first in the three out of the first 10 years, you can decide any 3 financial years that should be consecutive, wherein no tax will be applicable on you. You will avail a tax holiday. So instead of having a revenue, instead of having the profits, you don't have to pay any tax, but you have to decide that would be applicable only for 3 years in the first 10 years, and these 3 years should be consecutive, right? So 21, 22, 22, 23, 23, 24. This is how the consecutive word goes. So it should not be like 21, 22, then there is a gap, then 24, 25, then is a gap, then 26, 27. No, this is not the way. It has to be consecutive. You have to decide when you want to avail this thing, but that has to be availed in first 10 years of the incorporation, right? Now, what are the common mistakes which a startup does, and which a startup commits, basically, wherein the red flags come into the picture, or wherein the investment gets stopped or stuck up, or where the investor says, boss, I'm not interested. So the very first common mistake that we have seen is under the Companies Act. You guys are not maintaining the proper records. Startups are not maintaining the records. There are no meetings have been shown, no registers have been maintained, no shared certificates had been issued, or a lot of time we have seen that the incorrect filings have been made. You guys have not made the filings properly. Filings with the wrong amount has been made. You have raised an investment of say 1 crore. You have filed a document of saying 1.5 crore, or so a lot of things, a lot of non-compliances that we have seen under the Companies Act, and this is a main pain point for the investors, right? Licenses and permissions, you don't have the proper licenses, like Shop and Establishment Act. You guys are not taking the license. You have not registered yourself with the PF authorities, or maybe gratuity or ESI, right? These are the things that you are not getting registered with. Intellectual properties, unregistered. Let's say you have an innovative idea, you're working on it, but you have not got it registered, or maybe registered in the name of the founder, right? So this is where the problem comes in. So these are the common mistakes. Other than this, website we have seen, because see, every startup will have a website, but we have seen that you don't have a proper privacy policy. Domain registration, this is again very important. Like, let's say you have a website, you have taken a a URL which is not registered in the company's name. That URL has to be registered in the company's name, right? So that you have to make sure. Employee consultant labor relations, like you don't have an employment agreement. Let's say you have employees, but you have not issued any employment letters to them, or there is no offer letter to them, or maybe you have issued ESOPs without having any ESOP policy, right? So these are the things that we have taken. Litigations. So we have seen that there are few litigations pending which are not being properly reported during the due diligence. This is due diligence is very important from a perspective that we expect that whatever is the current situation, you let us know. We have seen that sometimes that, even the startups have tried to hide the details, but somehow we, by the help of Google or maybe help of with other apps, try to get the information about various litigations which are pending. So the litigation is something which has been seen as a very, I can say a very, a thing which is a very big red flag for an investor, because investor does not want to invest in a company wherein there is already litigations going on against the company, or maybe against the founders or directors. So this is where the problem comes. So these are the common mistakes that we have seen during our due diligence process, right? And I have highlighted these things to you just to make sure that once you are going for a fundraising process, you have to make sure that all these common mistakes should be covered with, right? Okay, so this is the end of my presentation, which I have prepared for you guys. Now the house is open for any sort of FAQs. So I have received few FAQs. So the participant have already issued few, have already raised few FAQs. So I'm just going to read few of the FAQs, and most of the things I have already replied during my presentation. All my the slides that I have prepared, I make sure that whatever FAQs that you guys have raised, I will try to cover it in this, but I will again read out the FAQs, few of the FAQs, and see that how I will respond to it. So one of the FAQs that we have received is having a chartered accountant to do annual mandatory compliance is sufficient since startups do not have much budget and revenue initially. See, you can have any professional engaged for this, maybe a chartered accountant, maybe a company secretary, maybe a lawyer. But being a founder, you have to make sure that you tell him or tell her very clearly that, boss, see, we have to maintain these documents as per the law. So whatever filings that you are done, that should be properly checked before, the data should be properly checked, and they actually maintain all the records so that once the due diligence process will start, we will get these records for the purpose of due diligence. What we have seen is that many times we are not received the documents for the purpose of due diligence, and the simple answer given by the startups are, sir, hamara CA hame nahi de raha. So, boss, see, this is where you have to make sure that whatever professional you want to engage in, you just have to make sure कि वो professional ऐसा हो जो हमें documents दे दे whenever the process of due diligence will start, right? Then there is another question that for a first time founder, what are the key things to be always be aware of? See, for a first time founder, you have to make sure that obviously you would be working on your innovations and your product, but from a compliance perspective, just make sure that you have all the proper documents available with you, because as a founder or as a startup, you will always go for fundraising, and these documents need to be maintained by you. So just make sure that documents are maintained. Website domain name should be registered in the name of the company. IPR should be registered in the name of the company. So these are the things that you have to make sure, right? Then there is there is a question about, tell us some examples of mistakes. I think that I have already covered that. I have already given the common mistakes that we have seen from a startup end. So I'm not going to repeat that question. Then there is a question that how will be fund raised in second round of investment? What are the prerequisites? See, first round ho, second round ho, third round ho, in every round, these are the things. This is the same process that will happen. So again, term sheet would be there, DD would be there, SHA, SSA would be there. So nothing changed in case if you are going for a further round of funding, but you just have to make sure that in case if the preemptive rights are there with the shareholder, then you first offer to them. Or what will happen in case of ROFO, that you have to make sure with your existing SHAs, right? What are the advantages and disadvantages of both private limited and LLP for fundraising? See, I'll recommend, so I'm not going into the advantages and disadvantages thing, but I'll recommend to go for a private limited company, because in our 99% transactions, investors are willing to invest in a private limited company rather than an LLP, because LLP will have a different set of a structure, and it will become more problematic in case if you're going for a further round. So company is always a better structure to have, a very simpler structure to have. So I will recommend to go for a company structure rather than going for an LLP structure, right? Then there is a question about how faculty can be involved and part of student startup companies. Because that can be done through a mentorship thing, or that can be by making him an advisor of your company, maybe a director or shareholder of your company. So by any way you can involve your mentor or your teacher or your faculty in your startup, right? Then there is a question about how we can raise a funding without dilution of equity, how it can be possible. So boss, I have told you in the initial slides that equity is not the only instrument. You can always issue CCPS, which is compulsory convertible preference shares. Maybe you can issue CCD, which is compulsory convertible debentures. Maybe convertible note. Being a startup, you are already you are allowed to issue convertible note also. So equity is not the only instrument, and I'm telling you, in 90% transactions, equity is not being issued by the founders. It is always CCPS or CCD, which have been issued by the founders for the purpose of getting the investment, right? So these are the few things, and now the house is open. In case if you want to raise any queries, please let us know.
Good afternoon, sir.
Good afternoon.
So one question related to slide number 23.
23. Okay, let me just go up and let me know which slide you're talking about. I don't have the number in front of me.
Benefits to startups.
Sorry?
Yeah, this one.
Okay. Okay.
Not this, sir.
Okay.
20,
कौन सी?
page 23.
ये मेरे सामने ना सर एक्चुअली में पेजेस नहीं आ रहे हैं. ओके, दिस वन.
Next. Yeah, this one.
ओके, हाँ जी
तो
बताइए.
इसमें दो क्वेश्चन है. वन
हाँ
इज
जी,
जो years का टैक्स हॉलीडे है, डज इट मीन
हाँ
कि
जी.
30% से फ्लैट 0% हो जाता है या एमएटी लगता है?
सर देखिए, इसमें ये है कि जनरली इसके अंदर हम 0% मान के चलिए. एमईटी की बात आती है बट 0% में भी इनकम टैक्स अथॉरिटीज मान जाती हैं, बिकॉज टैक्स हॉलीडे इज समथिंग जहाँ पे 0% के ऊपर भी ये लोग काम चला लेते हैं. हालांकि दैट मीन्स इट्स अ ग्रे एरिया, बट 0% हम मान के चलिए.
ओके सर. एंड सेकंड थिंग इज, जो फर्स्ट टू बेनिफिट्स इसमें आपने लिखे हैं, कैश फ्लो स्टेटमेंट का एग्जाम्पशन है और एनुअल रिटर्न जो है डायरेक्टर कर सकते हैं, वो अप टू 10 years रहेगा फ्रॉम डेट ऑफ इनकॉर्पोरेशन?
Till yes, everything is for, because you will going to enjoy the benefits up to 10 years for a
Okay.
startup. First 10
Right.
years you will enjoy all these benefits.
Right. Thank you, sir.
Sir, good afternoon. Yeah, sir, actually we are working in a project of ICMR under IIT KGP, and we are working on medical devices. So when we are filing the patent, that will come under the name of ICMR as well as IIT KGP. We will be only the investors. We will be only the innovators. Then
Okay.
if we proceed with the company registration, with taking this patenting right to us or to our company, will it be a problem as you think for raising funds? Yes,
See,
please
it
guide.
will, honestly speaking, it will be a problem because, see, as I've said, IPR, generally investors would like that all the IPR should be in the name of the company. But in this case, since you are going for an innovation wherein already your institute is involved, so you may take an assignment, you may take some sort of assignment agreement, you may enter into an assignment agreement, but again, it will depend upon that how you are going to convince your investor for this. Because see, it's ultimately an investor call, right? So sometimes we have seen that investor have agreed for an assignment thing wherein they see that, okay, there is a problem with an existing registered IPR. So sometimes they may agree to it. So it's all depend upon the negotiation. But yes, this is something which investors would always feel to have it with the company. So it would be a thing that you have to be, that needs to be negotiated at a very good level with the investor. You will try to convince him that, boss, this is not possible, but we will take some sort of assignment and let's see how the investor will go. But that being said, it should be better if you'll get it in your name, in the name of the company.
Okay, thank you, sir. And I have one follow-up question, sir. Please.
Yeah.
Actually, you have mentioned that valuation should be done by any chartered accountant, people, consultant. So, how the startup valuation comes under picture, because they don't have any much property, much sales, revenue streaming, anything else. So, sir, please guide.
Okay, so sir, this is under the Companies Act. When you are going for issuance of shares under the private placement, you have to done a valuation of your company. So this is where the valuation comes into the picture. So this is which is mandatory under the law. So this is not that investor is pressing, this is mentioned under the law. Now, how you will get the valuation since it's a early startup? So, sir, there are quite a ways of doing an valuation, and one of the ways is known as discounting cash flow, which is DCF method, wherein the valuation is done basis the projections of your company, the projections of your financials for next 5 years or 6 years. So basis that projections, the valuation can be arrived at. So this is a very common thing for all the startups, that they are saying, we don't have any asset, we are in pre-revenue stage, how can we have a valuation? So by using the DCF method, by using the projections, the valuation can be arrived at.
Sir, for that particular purpose, how the marketing strategy could be done in, in your way, for valuation or sales volume, how could that be reached?
Sorry, didn't get you. Didn't get your
Sir,
point.
actually, number of units sold per year on basis.
Right.
Right.
how that could be assumed at the startup level?
So that you have to assume considering the market situation, considering the industry in which you are working. You can see the other peers how they are doing, or you can see you can work on a demand scenario, that how the demand will come in a future. Let's say as of today you are selling say around 1,000 units in a year, but you are anticipating that in the next year, due to increase in demand or due to these factors, my unit will be sold from 1,000 to say 1,500 or maybe 2,000. So you have to evolve a strategy and tell the valuer that this is how you think, and depending upon, so it all depends on the market condition and demand supply role, the industry in which you are working. You have to give the future projections. So future projections are something that I will not say that it will give you a exact picture, but it will give you a brief idea that how you are going to progress in the next 5 years, basis which this evaluation will be done. So it will depend upon company to company and industry to industry and sector to sector in which you guys are working.
Okay. Thank you very much, sir. Got your point.
Sir, I have a query. My LLP was formed on the 6th of June, 2 months back, and I
Okay.
haven't appointed an auditor so far for the LLP. So, like private
Right.
limited, there is a 1 month of a kind of a thing. No? Within 1 month for a private limited, I got to appoint an auditor. LLP का
Right.
उसका कुछ है sir deadline?
LLP may you don't need an audit in case if your contribution is not more than 50 lakhs or your turnover is not more than 25 lakhs. Some amount is given, so there is no need of appointing an auditor right away. In case if your contribution or your revenue goes, only in that scenario you will need an auditor. Not as of now.
Then what should I do for the LLP, sir? Because I got nothing of it. I mean, I don't have any turnover. I mean, my turnover won't be even 50 lakhs this year.
So you don't need an audit for this. There is no need of audit.
So,
This LLP Act gives you a relaxation for it, and the investor also knows that you don't have to appoint an auditor. So they will also consider this point at the time of doing their due diligence. However, you have to maintain the accounting transactions. You just have to maintain that whatever revenue or expenses that you have, there is a proper accounting entry in your sheet. You don't have to go for an audit for it.
But I'll have to file an income tax return, right? Next year in March.
That you have to do. So income tax return would be there.
So that I will
GST
require
return.
a chartered accountant.
Yes, you will require a chartered accountant for maintaining the records, and basis that records an IT return can be filed. But there is no need of having a formal auditor in your company.
Okay, great. And sir, see, I really liked your presentation because for me, a lot of things were an eye opener about shareholder agreement and what is the detail of the due diligence which you told. Because I will be applying under the Startup India seed funds and everything. Now, sir, what my query is this, that I had earlier spoken with a couple of CAs, and right now my company doesn't have any turnover or nothing. So, in fact, yesterday only my private limited company got formed. I got the certificate yesterday only I got the company formation certificate for the private limited. So I had earlier asked about the fees. Abhi to kuch, there is no turnover, I'm bootstrap, absolutely on a shoestring budget. But everybody is talking about at least 50,000-60,000 rupees per year is my fee that I would give for a CA auditor, the GST and all that things. 60 to 50,000 minimum. So iska koi basis hai kya? That is one. That is first.
No basis.
Auditor, one company even told me that I calculated his everything. I asked him, अच्छा मेरा अगर कल 1 crore turnover होएगा तो आपका fee कितना रहेगा? तो he gave me a reply. It worked out to 1 lakh. Then I said, कल मेरा 10 crore होएगा तो immediately from that 1 lakh he became 10 lakhs. I said, you mean to say you are charging me 1% of my turnover? Am I doing business for you? मैं रिस्क मैं उठाऊं, सब टेंशन मैं लूं और तुमको हर साल का 1% मेरा टर्नओवर का मैं देने का, ये कौन सा स्कीम है भाई आपका? इसका what is the real payment that one should do to a...
So see, I also belong to the same fraternity, right? So I will not comment on it. But
ये गलत है सर, आप बोलना चाहिए. नहीं sir, you are guiding the young Turks of the India. So you are the senior position right now.
So sir, I think you should get in touch with other chartered accountants also and try to see the fees, and then you can evaluate. See, in the initial years, honestly speaking, there won't be much work. So you can always negotiate on the fees that, boss, for the initial these years, I will not pay you much because I'm in a pre-revenue stage, or maybe I have just started to earn the revenues, but I will increase my fees at the time if I will exceed a particular milestone. And at that time, whatever fees would be there, I will at that time discuss. So see, there are so many professionals which are available in the market, and all the professionals will not charge you this high fees, right? There are professionals who will work for lesser amount also. It's more about that how you're going to approach them. So there is no standard fees as such for a particular. So let's say there is a person who incorporates a company with say 1,000 rupees also. There is a company which incorporates another company say with 50,000 rupees also. So there are all these avenues are available in the market. So I cannot say that you should go ahead with that guy. But what I can tell you is that other professionals are also available. In case if you're not happy with the amount of fees, then you can look out for other professionals also. And you will find professionals from all these ranges, right from 10,000 rupees to 10 lakh rupees. It's more about how you're going to contact them.
So I will, sir, what happens is, see, I'm an engineer, I come from that background. So मैं आपको एक simple सा case देता हूँ. Suppose tomorrow my turnover is 1 crore and the amount of bills my clients will be 20. Per client is around 5 lakh rupee का मेरा bill रहेगा. So for 20 bills I have to pay GST. मेरा 1 crore का turnover है and 20 clients are there. तो इसमें workload कितना है मेरे chartered accountant का?
Sir, honestly
For 20
speaking,
bills.
I am not a chartered accountant, right? So I can't comment on that how much work a chartered
हाँ बट
accountant.
नहीं ये तो सर वो भी है वो तो मैं भूल ही गया.
Companies and
Company
prospectus.
secretary also for this type of a thing.
So for
Gautam
company,
sir, can I speak for a little bit? Gautam
Yeah.
sir, actually even like we are a young company, one young startup. We also went through the entirely like same situation, sir. And after a lot of recommendation, we were able to find CA and CS which were quite affordable, keeping in mind that there's not a lot of efforts that have to be put at least for the initial 2 to 3 years. So post this call, I can, if you want, I can connect you with them, and I think you would be happy with the numbers that they show you, or the quotation.
Please. Thanks. Please do.
No problem,
I'll be grateful.
Yeah, no problem at all. If you have any more questions, please continue. I'm so sorry.
Yeah, I have a question. This is Neeraj Mittal.
so your voice is breaking.
This is Neeraj Mittal.
Yes, sir.
We are a business incubator in Greater Noida.
Right, sir.
Students come to us with various ideas, and each idea obviously has a product also.
Right.
Now, relating the given product with the precise HS code is a difficult subject because precise information on any website or any portal of Government of India is not available. Can you please help us how to go about this issue?
Sure, sir. Can we speak about this offline if possible?
Perfectly all right. Yeah.
Okay, sir.
And sir, one small request. आपका ये PPT हमको मिल सकता है, so I can keep it for my knowledge sake. References
Sure.
आगे बहुत काम में आएगा.
I will share it with Ankit sir. So Ankit sir will take up.
Diviay sir, I have one quick question. आपने बोला था कि domain register करवाना है. Definitely, I just want to say that this was very helpful. This particular session was really helpful. Thank you so much for taking your time out and taking this session. Apart from that, like again, and I know eye opener definitely, but like the things like domain registration, आपने बोला करवाना पड़ेगा for company. Who is the right person that we should be going to? CS, CA, या फिर मतलब some government authority? I have no clue about that.
Domain registration is generally done by you can move to any person who deals in the IPR. That would be better because see, for every field there is a professional. So for domain registration, I will advise you to go for an IPR attorney. He will.
So that's my legal team then. My legal team, right?
Yes.
Gotcha.
Yes.
Okay. Thank you so much.
Okay, I would like to thank everyone for attending this webinar, and especially we would like to thank Mr. Chadha for this outstanding and elaborate presentation that explains the crucial legal aspects and documentations required to ensure a seamless fundraising journey for any startup. And we would once again like to thank you for taking out valuable time for this webinar, Mr. Chadha. And in the future, we will keep planning such sessions. Thank you. So it's an honor to be part of this webinar, and thank you all the participants and IIT Kanpur Incubation Center for arranging this. And pleasure meeting you everyone. And in case of any queries, my email ID is mentioned over here. So you can reach out to us in case of any queries. We'll definitely be able to help you out. And our numbers are also mentioned in case if you want to reach us for any queries, we'd be happy to help you out. Right. Absolutely. Thank you. Thanks Thank you so much. Thank you, sir. Take care. Thank you.
Thank you, sir.
Thank you, sir.